The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored.
Kenny and Nehemiah Nelson that he said multiple times, I can't breathe. We know that when he couldn't talk anymore, he just cried and wailed. And then eventually he stopped moving and he stopped talking. And nothing was done by these defendants. When he was finally handcuffed, they left him face down for 2 minutes before he was rolled over, before he was set up against the post, before his pulse was even checked. And Hoy told you that when they gave him a cup of water, it just rolled down his mouth. And he did not move, he did not talk, his head was slumped forward. You're going to get an instruction about self-defense. And again, this is a self-defense instruction. Don't read it. It's really small. In the state of Michigan, ladies and gentlemen, if someone is threatened with deadly force or non-deadly force, they are legally allowed to respond with like force. Now, if somebody pushes you, you can't stab them. You can push them back, you could probably punch them, but you cannot stab them, you cannot kill them for what is minor injuries. What you have to decide, ladies and gentlemen, is if you think that this is self-defense, was the defendant's belief honest and reasonable? And I'm going to tell you right now, the answer is no. And this is why the answer is no, because when each one of these defendants came into contact with Mackenzie Cochran, he was not a threat to them. You heard from the civilian witnesses who were there, not once did he throw a punch. Not once did he throw a kick. And for most of this altercation, he's on the ground and they're on top of him. He is not a danger. And at the point when he stops resisting, he is no danger to anyone. So it is definitely not self-defense. And the most common sense answer about why this isn't self-defense, because 5-on-1 is hardly self-defense. It is hardly fair. And when Mackenzie Cochran is on the ground and he's being held down by 4 others and you decide to hit him, that is not self-defense. And ladies and gentlemen, I don't know if you saw this in the video, but if you watch Exhibit 17, you will see the defendant Aaron Murray strikes Mackenzie Cochran while he's down. Don't take my word for it. It happens real fast. But just before that lady in the camel coat walks past, he balls up his left hand and strikes Mackenzie Cochran. Now, there's only one count before you, ladies and gentlemen: involuntary manslaughter. And if you look at all the evidence and think about all the testimony, you will see that all the boxes are checked here, and that these defendants are guilty of involuntary manslaughter. And so I'm going to leave you with this. When a man says several times, "I can't breathe," common sense says that these defendants should have repositioned him. They did nothing. When that man is too weak to talk anymore and all he does is wail and cry, common sense says the situation is dire and action needs to be taken. These defendants did nothing. Gavin King, when that man, becomes unresponsive, he's handcuffed and he's laying prone for 2 minutes before anyone even thinks to turn him over. Common sense said that these men needed to act, and they just stood there waiting for someone else to fix it. Gavin King, John Sieberlin, and Aaron Murray did not use their common sense on January 28, 2014, ladies and gentlemen. So I'm going to ask you to use your common sense today and find them guilty of involuntary manslaughter. Thank you.
Good afternoon, ladies and gentlemen of the jury. I would like to introduce you to a term that we use in law school. It's called IROC. IROC is something that we use to learn law, and it's the issue, rule, analysis, conclusion. Whenever you go take your law exams, that's what we use. So I'm asking you to use the same when you do your analysis. Look at the issue. What's the issues that's being presented? Involuntary manslaughter, self-defense. Then look at the rules that's given to you when you're giving your jury instructions. Those are the laws that you are supposed to abide by when you're trying to do your next point, the analysis of what you've heard during this trial. In your analysis, analyze the law and the exceptions to the law as well. Compare the defenses, and finally come up with your conclusion of your IROC. The judge started at the beginning of the trial and said that this was involuntary manslaughter, and she gave you 3 elements of the involuntary manslaughter. 1, that the defendant caused the death. 2, that the defendant acted in a grossly negligent way. 3, that the defendant caused the death without lawful excuse or justification. Each and every one of these elements must be proved, every last one. As the defendant causing Mr. Cochran's death, I believe that the prosecution has not proven this element of the case. Even their own witness was not conclusive in his manner of death. We presented a witness that was too contrary of his beliefs. I believe that our witnesses was credible in his analysis. Gross negligence is willful and disregarding of the results of another that might follow from an act or failure to act. Each of these elements, again, must be true. that the defendant knew of the danger to another, and the defendant took ordinary care to avoid injury to another. The defendant could have avoided injury by using ordinary care. And third, the defendant failed to use ordinary care to prevent injury to another when to a reasonable person it was expected that the results was likely to cause serious injury. The evidence shows my client was called to the jewelry store because of the jewelry store owner said that there was a person there who was threatening to kill somebody. My client arrived there with his sergeant and asked Mr. Cochran to leave the store and did not prevent him from leaving the store. My client knew of the threat that the store owner and he personally witnessed the assault upon his sergeant. Earlier during testimony, I asked several times from different witnesses what was an assault. An assault is a crime, and it does not require a battery, which is an actual hitting. All it needed would be a threat of a belief that you're about to be hit or harmed in some unwanted way. My client also, you will see after Mr. Cochran, you just showed in the video, he stepped away. I personally don't believe he was sprayed then, but it was the second time that he came towards Sergeant Chafin that Sergeant Chafin sprayed him because he was afraid, and that's when he bent over. That's how I know a person is sprayed with pepper spray. If you've ever been sprayed with pepper spray, you're going to have some reaction. It was that witness by my client when he stepped towards the sergeant a second time that he saw an assault again. And you have a right to defend not only yourself but another if you see an assault. I believe that is what my client did. I believe that's what he saw. I believe that's what Mr. Cochran did. He saw Mr. Cochran assault my client's boss, the sergeant. And it is also their duty to make it safe for not only himself, the sergeant, but Mr. Cochran, the situation safe, because one, Mr. Cochran had on a large coat. Yes, it was wintertime. He's already threatened to kill someone. They don't know if he had a weapon or anything on there. So the best action, as it was testified earlier today, control the subject, put the arms behind the back where they're not a danger to themselves or present a danger to the officers. He said, I believe he said they could use the handcuffs as a weapon if they're in the front. And that's, I believe he also said if they are in the front that they would be, I guess, tied to the front, a front chain or something. My client also, you saw in the video that he helped to secure Mr. Cochran's legs by holding him down, and the officers got Mr. Cochran under control. But once he was handcuffed, he was released. You also will see inside the video that Mr. Cochran's turned to his side. This, from my understanding, the whole video, someone testified it's 11 minutes long. They also testified today that the initial incident with my client and the Sergeant Chafin was about 2 minutes before the next person came. You also heard that that my client and Sergeant Chafin could not handle this man, so more people came to help just get him under control. You'll see in the autopsy there is no bruising around the neck, there is no punches or damages anywhere else except for the fingers. My client did have an honest and reasonable belief that the use of force that he needed was necessary to protect himself and people from the mall from an unlawful force by Mr. Cochran. He was defending himself and others. And I also want to remind you, as the burden of proof for the defense is on the prosecution. They must prove that my client was not defending himself or another. No one has stated that there was a chokehold, kicking, punching. It was holding. There was no strangling of Mr. Cochran. No one tried to harm Mr. Cochran. Earlier, also asked the question, what if, of several of you. My question now is, what if Mr. Cochran would have had a weapon? What if my client did nothing, as Mr. Hale testified that they would have done nothing? What would have happened to a sergeant if he would have done nothing? What would you have done in a situation? You can think about what you have done in this situation. And I believe that all the officers stuck to their training and to what they learned in the manual and how they dealt with neglect. I don't believe that this was ordinary neglect, let alone negligence. I don't believe that this was ordinary negligence, let alone gross negligence. There was testimony that there was crime and violence inside the mall often, and no one really testified whether anybody else had been seriously harmed in telling the people just to leave. So look at the fact that when Mr. Cochran was asked to leave, what was his mindset? Someone was talking about mental illness earlier. I don't know. But please do think about that. You must determine if my client was the cause of this death. Testimony was given that Mr. Cochran, she just stated, had an enlarged heart, and he had. Testimony was also given that he had smoked weed. Please evaluate that. So, what is the true cause? Was it the large heart taken into effect with his resisting? And she stated in the manual, it says, if you don't, basically she was saying something about if you didn't see it, basically you can't do the arrest. My client saw the assault. He saw the assault of his sergeant. He was a direct witness of the assault. In that point, once he saw the assault, he had the right of going by his manual, getting the person under control. The manual says, get the person under control and then handcuff them, and do not let them go until the police get there. This was his right to defend the sergeant. Punching and kicking is not the requirement. Once my client saw the sergeant getting assault, it was self-defense. There was also testimony showing that my client not only tried to give Mr. Cochran water, he checked for his pulse. You'll see in there that he checked for his pulse, and that they put him on his side. I'm not really sure who put him on his side, but it was testimony. Someone put him on the side. In the end, I just ask that you rely on your knowledge, your experience, and the facts that we're giving to you to make a common sense, or also look at the circumstantial evidence. You look at the body languages in the video, make your decision. I hope that your decision is that my client is innocent. If my client is innocent, the rest of them are innocent.
Thank you.
Ladies and gentlemen of the jury, it's with great honor and respect that I come before you this final time and address you on behalf of my client, Mr. Aaron Marie. Like Sister Counsel, I appreciate your services, your commitment to this case. I know that you've been taking notes and you've been very point on as to your attention in this case. And it means a lot to us because you have a right to a trial by a jury of your peers, and we feel that that's what we finally have in this case. Keep in mind that what I tell you right now is not evidence. I wasn't at this decrepit mall. What the prosecutor has told you, she wasn't there either. It's just basically a wrap-up and pointing out poignant things in this case that we feel are needed. I'm not going to rehash everything, so you can say, thank you, Mr. Blake. We've heard enough. But in any event, once again, as Mr. Marie sits at that chair, through his lawyer, he indicates to each and every one of you that he is not guilty of these charges. And it's hard for him to take this. It's been 10 years. 10 years. And one of our constitutional concepts is the right to speedy trial. Every citizen has that right. So what the heck happened in this case? And there's a reason for speedy trial, because it's like that food off of the stove. You want to get that meal when it's nice and hot. You don't want to wait a week later when it's cold and soggy, spoiled. Well, what happened in this case? And once again, there's a reason for speedy trial. One of the individuals whose name has been dragged through the mud, Sergeant Chafin, is not here to defend his honor. The officer in charge of the case retired. Memories faded. That's why we have speedy trial. So, when this incident happens, there's an investigation, and there's been a lot about manuals in this case. Security guards' manuals. Let's not be fooled. Security guards are low paid, long hours, poorly trained individuals. It's not like they're in the police academy going to Guantanamo Bay studying up under FBI experts. They're security guards trying to make a living. My client started out that day going to work, doing his work, and wanted to come home after work. But for Mr. Cochran, it did not happen the way it normally does. Now, Mr. Cochran, it's puzzling about this individual. We know his height, we know his weight, we know the marijuana part, and we don't even know a lot about him through his property. The property, there's some money. The property, there's a cell phone. And apparently it's not a smartphone because we don't have text. We don't have the course of his, where he was going that day. We don't have his mental state of mind. We don't have him calling out to individuals, hey, I'm at this mall. So we get nothing from that. He doesn't even have car keys. We don't even know how the heck he got to the mall. And up under what circumstances. Prosecution said he wanted to go home. We don't even know if he had a home. You don't know anything about him. We don't know anything about him. The mental illness part. Well, once again, his behavior was not normal. How extreme? Did he have a mental illness? We know absolutely nothing about this young man. No family members have come up to tell you anything about him, about his whereabouts. his mental illness, if any, existed. So we got that void, and they've had 10 years to get into that. But once again, why did it take so long? After it happens, the Southfield police investigate. My client readily cooperates. He gives a statement to the police. They go back to work. You don't hear about from the agency that they violated the agency's policy in the arrest of this individual, that they were negligent, that they didn't follow the handbook, the guidelines, whatever you want to say. So then you get into the investigation. You have the videos, the statements. They had all of that way back 10 years ago. And you heard from Dr. Dragovic. You know, this wasn't something that was just glossed over or passed over. That auditorium, that big auditorium that's in front of this building, up under that big 1,200 sign, was filled with individuals from this county, whether or not to prosecute this case. They had all of this information that you've had a chance to listen to for the past week. They had it all 10 years ago. No charges. There was no negligence. So, what changed between 2014 and 2021? Well, I guess the Attorney General calling up Dr. Schmidt. And that's interesting. Why is she calling Dr. Schmidt? Who's pressing her to even look into this case? Is it her family? Is it for her own political gains? Make some headlines, be on the news like this week at Democratic Convention instead of being in this courtroom?
Objection, Your Honor.
It's only closing, Judge.
I know it's closing, but let's stick to the facts of the case, okay?
Well, she picks out this interesting guy, Dr. Schmidt, who apparently no longer works at Wayne County. He's now working in Monroe County. And he goes through this report. He doesn't perform an autopsy, and Brother Counsel brought up, something that just struck me as very critical, crucial. This is your new witness. He didn't perform the autopsy. He's not there at the dinner table when everything's nice and fresh. He's going over old information. He doesn't do a toxicology. He doesn't do anything. He doesn't have the body there, obviously. So the relationship between the Attorney General and Dr. Schmidt is apparently it's a contractual. He's claiming that I don't think I'm even billed for this. We don't even know how many hours he put into this case. I was stunned when I said, well, did you take any notes? Well, it's hard to remember what happened last week, let alone 2 or 3 years ago. How did you come up with the analysis in your 3-page document? We don't know how he came up with it. Dr. Dragovic had a case file that's been saved for this matter. Even though no charges were filed, he had a case file that's for reference. Because he knows lawyers are going to ask him, how did you come to this conclusion? Where are your notes, your analysis? Dr. Schmidt, nothing. And on his report, he reviewed the material received on this case. This included the following: security camera videos from the Southfield Mall. Videos that included media accounts and reporting from the incident. And cell phone, I'm sorry. I don't want to get you nervous, go ahead. This is from that report. Documentation of Mr. Cochran while being subdued. Documentation from Southfield Police Department and Emergency Services. Okay, so when we get to the cell phone, we don't know who he listened to and what. Videos that included media accounts and reporting from the incident. I'm stunned that he would even, we know he was listening to Fox. He listening to Channel 4. Why would he, I'm sorry, why would he, a doctor, a pathologist, listen to media in order to form his conclusion of this case? We don't know which police reports, which cell phones, we don't know. All we know is that he looked at something. The prosecution brought up something about my client making a motion with his hand in her closing argument. Didn't ask Dr. Schmidt anything about that. And we know for the autopsy report, it indicates there's a category that says evidence of injury. 2 small abrasions, each measuring 1/8, 1/8 inch in diameter, are noted at the base of the left third and fourth finger. No other injuries are present externally or internally. My client's a big man. He was then. Might even been bigger then. So if he's there trying to physically harm somebody, there would have been some marks. And that's why I asked, were there any abrasions? You got all these people surrounding Mr. Cochran. Any abrasions, bruises, trauma, soft tissue injuries. Other than those 2 cuts, nothing. Absolutely nothing. We know one thing for a fact. Aaron Myrie is not the first person there. We've heard many, many times how it started. And that's another thing, that the jeweler at LA Diamond, he's there by himself, probably thousands, if not $100,000s of dollars worth of product in a glass case, in an open area with, it's not like conventional door, wall. He's out there by himself, and this individual comes up to him that he doesn't know. And it was kind of chilling the way he testified. He said he looked like he had the stare of death. The stare of death. Not like he was kind of scary. Man, I looked at him and he was strange. Well, the stare of death, when we know it's true, because he goes and gets his gun. He gets his weapon and puts it in the bag. And he still can't get rid of Mr. Cochran, and he does the next best thing. He calls repeatedly to security. Mr. Myrie is not in the area. He's running to get there, running down to the dispatch, running to the scene to assist fellow officers. When he arrives at the scene, Mr. Cochran is already down. And you've heard things about the kicking, the fighting. That man's kicking a lot. He's fighting, and then you hear some words. All he had to say was, "I give up, here are my hands, stop it." But he keeps fighting. He keeps fighting ferociously. Those legs are kicking, and these officers are doing everything they can to handcuff him. And, even the Southfield police officer said, the double handcuffing, they're not trying to take one cuff, put those arms behind his back. They're just trying to subdue him because they don't know if he has a weapon on him, a gun on him. They didn't have a chance to frisk him. They didn't have a chance to go through his pockets while they're trying to put handcuffs on him. And as you've heard from the expert, you know, if they're wrong, Lord knows how many people can be impacted in this case. If that guy, Mr. Cochran, actually had a gun, we're in a mall situation, all too many times now, it's like on a weekly basis. Multiple people are getting killed, innocent people are getting killed in public places. So this is a judgment thing that is going on. It's in real time, it's going like that. Mr. Marie doesn't have time to discuss, hey man, what's the situation? Or he doesn't say, well, dispatcher. They say, get on up there. Assist those officers. Assist your sergeant. Secure the situation. There's no evidence that he takes his handcuffs and puts them on Mr. Cochran. There's no evidence that he takes them and props them up on the pole. The evidence that you've seen in prosecution didn't go through that is the water. After he wipes himself from all of this activity, the sweat, trying to get his breath, and they want to know, well, how come he doesn't go and assist Mr. Cochran immediately? You running through that mall, you trying to subdue someone out of breath, perhaps? But he tries to offer water. Does that sound like someone who is so pissed off with this person that they're trying to subdue them and beyond their scope of employment? No. When you look at it on video, it seems like forever. But once again, my client wasn't there that whole complete time. He had pretty much was already on the ground. He was pretty much already with his face down. And when you have the PEA, we don't know when the PEA actually even kicked in. So you submit all of this to the prosecutor's office, and then you have nothing, and then you come back with Dr. Schmidt, whose letter is pretty much all over the place, indeterminate, inconclusive. But yet, my client is charged with a case that no one thought would ever come to this point. He's charged based upon a decision, really the only new evidence. You know, you think about, wow, you know, where's the newly discovered evidence? Who's going to walk in here and say, they did it, or something else was new? Nothing is new. Nothing. Except the letter from, and the letter and someone looking over the medical examiner's report and the autopsy. That's the only thing. This 3-page letter that has references on it from Dr. Schmidt. He includes forensic reports from the journal, internet applications for predicted heart rates. So he can get on this internet and say, hey, he has an enlarged heart. Well, they're saying that has really very little to do with this case. And I agree. I agree that the major point in this case is the but for, and it's not but for Marie. It's not but for these individuals. It's but for Cochran. But for if you hadn't walked into that mall, this wouldn't have happened. But for if you hadn't act in a erratic, aggressive, flexing, dangerous posturing in front of a man who all he wants to do is protect his wares, protect himself. If you had just left when that officer said, please leave them all, please leave them all, there are so many but-fors that this should have never happened. And now they want to charge these young men with voluntary manslaughter. Ladies and gentlemen, you promised at the beginning when you were sworn to set aside all sympathy, bias, and prejudice. And we're going to hold you to that. We're going to hold you to, just like we're going to hold the prosecution, the government, to their burden of proof. That burden of proof beyond a reasonable doubt. And ladies and gentlemen, they didn't have enough 10 years ago, they didn't have enough 2 years ago, and it clearly doesn't reach beyond the reasonable doubt now. Ladies and gentlemen, thank you. We ask that you find Mr. Mari not guilty of the charge against him. Thank you.
Thank you, Mr. Blake.
Yeah, that's what's giving me a hard time. Yeah. Ladies and gentlemen, I wanted to thank you for your time, just like everybody else said, on behalf of Mr. King. We thank you for joining us this week. We know it wasn't by choice. Nobody wants to serve on jury duty. But every time I have a jury, they always tell me afterwards it was pretty interesting and they had a good time. All right? You did make the choice that once you were stuck with us for the week, that you would pay attention. All right? And you would take this case seriously. Because it is very serious to these three men. Is this a sad case? Absolutely. A man lost his life. It's sad. It is regrettable. We wish it didn't happen. But it is not a crime in this circumstance. That's one thing it is not. Not guilty is the verdict that Gavin King, John Seiberling, and Aaron Marie are entitled to. Not just because Gavin's my client, or John and Aaron seem like good guys, and they deserve it. Because the law requires it. Each of you promised us, and you took an oath to follow the law. And that law is that you return a verdict of not guilty if this case is not proven to you beyond a reasonable doubt. I try to get fancy like Miss Logan, but it's not working. Reasonable doubt. You're going to get these instructions, so it doesn't really matter if you can read it. I'm just putting it up there to draw your attention to it. It's Rule 1.9. And it defines reasonable doubt. It tells you the defendants are entitled to that verdict. But the only time in any of these instructions that it tells you someone is entitled to anything in this courthouse, but that a defendant is entitled to a verdict of not guilty if the government fails to prove that case beyond a reasonable doubt. Ladies and gentlemen, you should not be satisfied. You cannot be satisfied. Can anyone honestly say that after paying attention to this evidence for the last week, they don't have a fair and honest doubt? A doubt based on reason and common sense? A doubt that is reasonable? Of course not. Because reasonable doubt is all over the place in this case. Why are we here 10 years later? People don't remember anything. Now, you don't have to all agree on why it is you believe there's reasonable doubt. You can each have your own reason to doubt. There isn't just one reason, even though that's all you need to have to give a not guilty verdict. Each of you can have your own separate reason that you have doubt in this case. We're all getting to the same place. We might take different roads. We might doubt this. We might doubt that. At the end of the day, we all have reasonable doubt here. And we're all getting to the same place of a not guilty verdict that they're entitled to. Maybe except the government over here. Right? A little bit. Here's one. Where is Matthew Clark? You didn't hear that name, right? We know that name. Government knows that name. Read that instruction you're going to get. 5.12. Right? Matthew Clark recorded one of the videos that you have. Why is he not here? He's not dead. We don't know because the government failed to produce him. And like Judge Anderson will instruct you, that a missing witness was their responsibility to bring. All the resources at the state of Michigan's disposal. And they couldn't find this guy who they know lives in South. Still there. They didn't bring him. Why? I don't know. They didn't like what he had to say. Know why? Because he recorded that video, and he was making comments on that video. But since he's not here, we can't tell you what those comments are. That's the rule. So they didn't bring him here. How did this case start? It starts the day before Mackenzie Cochran's unfortunate death. When he puts in motion a series of events over the span of these 2 days, the final 2 days of his life. It starts when Mackenzie Cochran shows up to Labib Ansara's LA Diamond store at Northland Mall, and he freaks him out by just standing there giving him a death stare. Stare of death, he called it. This is the first event, and it only gets worse from there as he escalates it step by step. A man who is over 6 feet tall and over 200 pounds. We don't have to guess. I say, one witness said, I look like he was 5'10", one said he looked like he was 5'9". Look at the autopsy. Right? I mean, for the first time, defense attorney, we introduced the autopsy. Defense Exhibit C, right? The autopsy report's in evidence. Right there on page 2, it says he's over 6 feet, over 200 pounds. Look at him there on the video. He's towering over everybody. All right? He's towering over Sergeant Schaefer. Then after he leaves that day, he comes back with another individual to do the same thing and just walk off. Mr. Ansara's spooked, right? But he doesn't overreact. He just calls security to tell him what happened and to keep their eye on this man. Then he learns a little bit more serious. He went into some store where a young girl's working by herself in the mall. He freaks her out. She runs out of the store to get away from him. Now we fast forward to the next day on January 28th. And this unknown individual now returns to the jewelry store. And he escalates this menacing behavior from stares to the absolute worst type of violence. He threatens that he wants to kill someone. Mr. Ansara jumps back. You see him jump back off of his chair. He's freaked out. It is absolutely reasonable at that point to assume the worst. The man said he wants to kill someone. How much more serious do you get? When someone says something like this, you take him at his word. Get the heck out of there. Try to stop him. Mr. Ansara takes so seriously, he grabbed his revolver. He calls security for help. He isn't calling them to come observe and report. He doesn't want to just report who the man kills. He wants them to stop him from killing anybody. He wants them to stop him from carrying out his threat. He said it took him probably a minute or two, but to him it felt like forever. He called a second time. He said, hurry up or I'll shoot him myself. He was concerned enough to threaten deadly force. Sergeant Chafin arrived with this concern because we know they all knew about this. Because James Hale, the county dispatcher, hiding in the dispatch room, tells them, quarter LA Dime is the guy threatening to kill someone. He said that. Sergeant Chafin goes there knowing it's a threat I gotta take serious. Southfield Police Officer Jill Jacobs, she said she'd take something like that serious. She'd expect every police officer to take something like that serious. And it's reasonable, based on that threat, to assume he's armed with a deadly weapon. The expert Joe Key, who's trained for, I don't know, half the police in the country, I guess, agreed with that assessment. No one, not one, has testified otherwise. No one has testified that it would be unreasonable to feel threatened or to not assume that the man has a dangerous weapon. Does Sergeant Chafin overreact? Absolutely not. He underreacts. He doesn't rush to use force, simply politely tells them, sir, please leave. This is what Hoy Monk heard when he was sitting there with his mom or his wife, and we see Sergeant Chafin motioning on the video towards the door. You know what that pointing means? Leave! Just like Hoy Monk heard him say. Does this unknown man who made threats listen and leave? Absolutely not. So now he's committing the crime of trespass. He's been told to leave, he's not leaving. Sergeant Chafin used force to make him leave? No. He tries to de-escalate. He stands there and repeats himself. Now this unknown man himself negligently escalates the situation again by clenching his fists, breathing heavy, and getting closer to Sergeant Chafin. This man is the aggressor. He's making the situation more and more volatile. He starts the series of events. Prosecutor wanted to point you to an instruction talking about if the defendants unlawfully injured Mackenzie Cochran and started a series of events that naturally or necessarily resulted in his death, it is no defense that he had a large heart. They didn't start anything. Mackenzie Cochran started the series of events. The man was given every opportunity to leave. Sergeant Chafin told him, sir, do not approach me. And he gets a little bit more firm. Sir, do not approach me. It was a pepper spray. He said a third time. Sir, do not approach me. The man does not heed the warnings. That would have been the right thing to do. That would have stopped this entire chain of events. Right there. But the man threatening to kill someone has other plans. He continues to escalate his actions. Hoy Monk sees this aggressor now longer take a step, he said, towards Sergeant Chafin with his fist clenched. What's he supposed to think is going to happen? This is assault. He's made a threat, and he's putting Sergeant Chafin in reasonable fear that he is about to unlawfully touch him. Sergeant Chafin is allowed to take action at once. He could have already taken action. He kept delaying and trying to de-escalate until he could no longer do so. He takes action to stop this assault from turning into an assault and battery, or possibly even a murder, as this unknown aggressor had threatened to do. So he said he's going to do. He pepper sprays him, as his training manual authorizes him to do on someone who has committed an assault. He continues to follow the training manual because it requires that an individual who has been pepper sprayed then be restrained with handcuffs until police arrive. He tries to get him under control. He orders Officer Simon to help him. He's a superior. Sergeant Chafin. Man, they said was a former police officer. He's the first on scene. He's in charge. He's also in charge because he's the sergeant. That's what the manual says. First on scene in charge until a sergeant shows up. But guess what? Sergeant Chafin, he's both. He's the first guy there and he's a sergeant. He's in charge until Southfield police arrive. The two of them cannot get this violent man who's potentially armed under control. The unknown man who threatened to kill someone is now getting the best of him. So when Monk said he's fighting him, yelling, "Get off him!" As James Hale said, from the comfort of the dispatch room, he's watching them get handed their ass. That's what he said. They need help. The signs are being kicked all over. It's spiraling out of control. A third officer gets there. Hoy Monk hears the public safety officers yelling, "Please stop resisting. Please stop resisting." To no avail. Still, no one overreacts by using an object as a weapon. Right? Nobody strikes any part of this man's body. As chaos is escalating at Northland Mall, 22-year-old Gavin King, the college student who made the mistake of taking a part-time gig at Northland Mall, showing up to work, and told, "Get up there. Man threatening to kill someone is beating the crap out of your sergeant." So he runs up there. Now, I believe that all three of these minorities, I believe either one of them committed a crime. But my job is to focus on Gavin King. All right? And instruction 2.22 will tell you that you as jurors are to focus on each individual separately as well. You should consider each defendant separately. Each defendant is entitled to have his case decided on the evidence and the law that applies to him. What did he do? Now, it's important to remember that we don't have to prove that they acted in lawful self-defense. even that burden stays on the government. The government must prove to you beyond a reasonable doubt that their actions were not self-defense. Gavin King has the right under our laws, just like any other person, to use force to protect himself and others if he has an honest and reasonable belief that he needs to do so to protect himself or other people from the imminent unlawful use of force by another. And I'm reading it word for word. You're going to have to copy this. If his belief is honest and reasonable, he may act at once to defend himself and the other people, even if it turns out later that he is wrong about how much danger he was in. Ladies and gentlemen, he was right. He was not wrong. Ask yourself, did the government even come anywhere near proving to you that Gavin did not have an honest and reasonable belief that he needed to protect himself and other people from just being touched, right, by the violent man who threatened to kill people and was fighting his sergeant and two other officers on the ground as he runs up there? Of course, that's what he believed. And it was absolutely honest and reasonable. He sees the struggle taking place on the ground. And what does he do? He does what he is commanded to do by his sergeant. He tries to grab the man's arms. You see him on the videos. All he does, he gets on his knees on the ground. He does not get on top of anybody. His knees are not on top of anybody. His knees are on the ground. And he is tugging at the man's arm. First, when he gets there, he's tugging at his fellow officer's arm. And look at it on the video. You see the other officer smack him. You idiot, that's me. He lets go and then grabs the violent attacker's arm. He tries to pull it out from underneath him so he can't grab a weapon or strike anybody else. Because nobody knows what he's got in that jacket. Nobody knows what he's got in his pocket, in his pants. We don't know. They don't know. They're trying to make a split-second decision. You know? They don't have 10 years, all right, and get a message with his friend, Dr. Schmidt, to decide, oh, put it on a little different. They're making a split-second decision. What do you do? Guy said he wants to kill someone. That one arm is the only body part of that violent man that Gavin ever touches. Not one witness said to you that they saw Gavin touch any other part of that man's body other than grab his wrist. We don't Monday morning quarterback this. All right? We don't get 10 years to think about it. We still did it. Holy Monk said it looked to him like they were trying to get his arms behind his back. It didn't look like anyone was trying to hurt him. Maria Nelson said the same thing. And that's because no one was using excessive force, ladies and gentlemen. No one was striking this unknown man who was making threats, even though he was being violent with them. And it was reasonable to believe that he was armed. Now, the government has been saying, I think it said it at the beginning, it said it right now in the closing, wasn't a fair fight. Mackenzie Cochran didn't have a chance. You know, it was 2-on-1. Then I got to 5-on-1 at one point. It doesn't matter. Guys, this isn't a sport. It's not a boxing match. This is not for our entertainment. This is real life, and there are real life consequences. A potentially armed man is threatening to kill someone in a mall full of customers, walking around minding their own business. I want you to imagine for a second. If at some point later on, after they got him under control, someone found a gun in that man's pocket, they'd be hailing these people as heroes. Right? They prevented a mass murder. Instead, 10 years later, not the Monday morning quarterback, 10 years later quarterback, all right, comes inside to turn their lives upside down. And say, we're going to charge you for involuntary manslaughter over that part-time gig you took 10 years ago at the Northland Mall. Officer Jacobs said that if she saw one officer struggling to handcuff an individual, she would help. If she saw two of them struggling to handcuff an individual, she would help. It doesn't matter how many they are, as long as officers are struggling to subdue an individual and handcuff them, the officer should help. They know that. The government knows that. That is all these men were trying to do. Gavin put one pair of handcuffs on one wrist, and someone else got a handcuff on the other, and they linked them together. Why? So they don't hurt the guy. Right? Like the evidence tech, Patricia Meyer said. And so you don't hurt a larger individual. Once they handcuffed him, they rolled him over to his side and then propped him up against the pillar. And would you look at that? What did I find in the 2,000 pages of their manual? A diagram. Tell him to do exactly that. Take him to his side, prop him up. Just like he was on the pillar. Officer Jacobs was an instructor in CPR and first aid. She said she would have done exactly what she saw them doing, checking for a pulse. In fact, even though she's got more expertise, she didn't tell anyone to step aside and try to take over. Ladies and gentlemen, we don't know when the death from what they refer to as pulseless electrical activity actually occurred. Right? Nobody's testified to that. We don't know if it occurred before he was even handcuffed at all, and that's the reason they were finally able to get his arms behind his back, or at some point later. Was it the fault of the drill that they forgot to charge the battery, the EMT, so they couldn't administer epinephrine? Was it because of the improper way that the tarantula tube was placed inside of Mackenzie Cochran, that it had to be readjusted when they got to the hospital? There are so many reasons to doubt in this case. Joe Key testified that the force these public safety officers was not lethal or deadly force. He felt they would have been justified in using lethal or deadly force, but one thing that didn't even come close, it was the lowest possible on the force continuum. He said they attempted to de-escalate it. They were doing the bare minimum they could to protect themselves. Don't believe me. Don't take my word for it. Watch the videos. Believe your eyes. Right? Now, Dr. Schmidt, the man who resigned from Wayne County under a cloud of controversy, which I don't know how that happened. I don't know how you get chased out of Wayne County. Right? But somehow he did. And he becomes the Attorney General, Dana Nessle's go-to hired gun. He said, yes, I am. He says after 8 years, he wants to second guess the findings of the Oakland County Medical Examiner, run by Chief Medical Examiner Dr. Dragovich. And why does he do it? He does it at the request of the Attorney General herself. Is that normal? The Attorney General herself called this man? So what do? Do you have the guts to call Oakland County and say, hey, I want to discuss this medical report with you guys. I found a couple of disagreements. Maybe I could bring them to your attention? No. That's not what he's trying to do. He slapped together, how do you want to call it a report? It's a letter. Right? It's a letter. And he did it on his own without consulting anybody. He said, oh, it could be homicide. It could be indeterminate. I don't know. Right? Because there's limits to how far he can fudge the truth, no matter how much of the taxpayers' money his friend Dana Nessle will promise him. He agreed, well, first, because he wrote that report, that letter, that's why we're here, all right? He could answer that question, why are we here? Remember Mr. Blake asked him, well, why are we here? Right? Because he authored that letter. They needed that letter. That's why we're here. Ladies and gentlemen, that letter might be enough for the Attorney General's office. It's not enough to convey. It should not be enough for you. Even the hired gun said there is doubt and it is reasonable. He lied to us about not planning to submit a bill. I'm going to check it out. I hope the Attorney General's office holds him to his sworn testimony that he will not submit for payment of $450 an hour, like he always does when they send him all over the state to Muskegon and everywhere else.
You have 1 minute.
I will. Ladies and gentlemen, he didn't do a thorough report. Dr. Dragovich did a thorough report. When he did it with peer reviews with the late Dr. Lowell, that was a real autopsy report. And what did Dr. Dragovich tell you? He got a call from Assistant Attorney General Orlando Patterson, right? Telling him to change would he change his report? And then what do you know? Look at who Dr. Carl Schmitt's letter is addressed to, right? Orlando Patterson.
You have to wrap it up, please.
I'm done. Dr. Schmitt's report is an exhibit. We introduced it. Take a look at it. This gentleman's case is full of reasonable doubt, not just because of the motivations for bringing it, because of the facts. There's reasonable doubt all over the place. The only just verdict is that which the instructions tell you they are all entitled to, not guilty. You want this back?
Justice delayed should never be justice denied, ladies and gentlemen. And just because in 2014 a decision was made not to charge this case does not mean that you should further deny Mackenzie Cochran justice. There was a lot of talk during the defense closings about Dr. Schmitt, James Hale. What I did not hear from any of the defense attorneys was what Mackenzie Cochran was saying, which if you believe no one, believe him. He said, I can't breathe. I can't breathe. And even Hoy said, initially I thought it was just a scheme for him to get the security guards off of me. But eventually it became more dire. Eventually it became crying and wailing, and then it became nothing. When it comes to proof beyond a reasonable doubt in this case, we have to start with what killed Mackenzie Cochran. And even both medical examiners, which neither one of them authored that report, by the way. It's authored by Dr. Cheryl Lowe. But they both say the same thing killed Mackenzie Cochran. Because he was restrained in a prone manner, his heart stopped. So that means we have to look at who restrained Mackenzie Cochran. And it was Gary Chafin, Aaron Murray, Lucius Hamilton, Gavin King, and John Sieberlin. And then you have to look at, did they owe him a duty of ordinary care? And the answer is absolutely. Because they know that that position, that very position that they put Mackenzie Cochran in, that very position that they kept him in, that very position that they held him down in when he said he could not breathe, could cause death. And it did cause death, ladies and gentlemen. So yes, they owed him a duty of care. They knew they owed him a duty of care, and they did not honor it. And that is why we are here. And that is why it should not matter that it's 10 years later, because Mackenzie Cochran deserved to be listened to on January 28, 2014, and they did not do it, so we need to listen to him now. A lot of talk, a lot of the defense focused on words that Mackenzie said when he walked up to L.A. Diamonds. Got nothing for that. As I told you in my closing, that would cause any ordinary person, any citizen, to take a second look, take a step back, and, you know, put some distance between yourself and the person who says, I want to kill someone. But you're going to get an instruction about intent. It's mostly aimed towards the defendant's actions, but it applies to any person. And you look at what they say, how they say it, what they do, and how they do it. And the only evidence that you had about this threat was that he said words. He did nothing else. He stood at the counter, and we can watch him standing at the counter. He doesn't bang on the counter. He doesn't pull out a weapon. He doesn't even try and enter the store. And as weird and concerning it is, it's not illegal. The
I
instruction.
object that her opinion that she stated that's not illegal is contradictory to all the evidence from the witness who said that was assault.
What, that he was standing there?
No, that he threatened somebody, and you said the threat in itself is not a
All
crime.
right, this is, hold on, closing argument.
Factually correct.
The jury saw the evidence and the testimony. Move on.
Thank you. When you think about self-defense, and you're going to get an instruction on it, and yes, it is my burden to prove to you that it wasn't self-defense, but all the evidence before you clearly shows that this is not self-defense because, one, the action has to be proportional. And there is no proportion to positional asphyxiation. If he's down on the ground, if he's handcuffed, who's he a danger to? All they had to do was roll him over. But they left him prone for 2 more minutes before they rolled him over. And even when they did that, they don't even attempt any life-saving measures. You can see on the Northland video, which is not great, but you can see that when they do roll him over, his feet just flop over. And then he's pulled up in a seated position against the post, and Hoymong tells you his head just slumps forward. He doesn't move, he doesn't say anything, he doesn't take the water that is offered to him. And the next thing we know about his condition is that he is pulseless electrical activity. And that is a direct result of the actions of those 5 security guards. And while the law says that you have to look at their actions, the facts as to each defendant individually, if all their actions combine to result.
I'm going to object. You're stating law that is not in the instructions you gave about combined efforts. No, you're talking about combined efforts, and that is not in the instructions, Judge.
Actually, acting in concert is a legal theory that I can talk about, and I'm alleging that they're acting in concert.
You've already set the instructions, and that's not one of them.
It doesn't have to be an instruction. It's still something I can discuss.
Continue with your argument, please. I'd like to instruct this jury before the end of the day.
Thank you. If you believe that all of their acts together resulted in the death of Mackenzie Cochran, they are all equally guilty. The defendants talked a lot about the manner of death. And you'll see in Dr. Lowe's report that she listed manner of death as accident. Manner of death has nothing to do with why we're here today, ladies and gentlemen. It is a classification that the medical examiners must do. But just so you know, and just as Dr. Schmidt testified, manner of death being an accident, that's as simple as a car crash. When people get charged for car crashes when they break the law all the time. You heard from Dr. Schmidt that it could be homicide, death at the hands of the other, but there's also the argument for indeterminate because it could not fit necessarily neatly in multiple categories. But the cause of death is very firm, and it's the same from both. So that is not something that creates reasonable doubt, ladies and gentlemen. Mackenzie Cochran should not have died on the Northland Mall floor on January 28, 2014. He shouldn't have died alone. So let's make sure he's not alone now, ladies and gentlemen. As people of the state of Michigan, I am asking you to care about what happened to Mackenzie Cochran 10 years ago. I'm asking you to be his voice, and I'm asking you to finally give him justice. Thank you.
Thank you, counselors. Members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it's your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. Every person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will just now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are also not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. As I've said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or social economic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. Gavin King, Aaron Marie, and John Siegerling are each on trial in this case. The fact that they are on trial together is not evidence that they were associated with each other or that either one is guilty. You should consider each defendant separately. Each is entitled to have his case decided on the evidence and the law that applies to him. If any evidence was limited to one or some of the defendants, you should not consider it as to any of the other defendants. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about January 28, 2014 within Oakland County. When you go to the jury room, you will be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you are in a jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. And as I said, when you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all of my instructions together as the law you are to follow. You must return a separate verdict for each defendant. This means that for each individual defendant, you may return a verdict of guilty of the alleged crime or not guilty. And I have prepared verdict forms listing the possible verdicts for each defendant. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial, a witness made a statement that may be inconsistent with his or her testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. In this case, I took judicial notice that Assistant Attorney General Orand Patterson appeared before this court as an attorney of record on behalf of the Michigan Department of Attorney General as a prosecutor in this case. This means that you may accept this fact as true, but you are not required to do so. Okay. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses Dr. Carl Schmidt, Dr. Lubja, I'm murdering his first name, Dragovic, who have each given you his opinion as an expert in the field of forensic pathology. You have also heard testimony from Charles Key, who has given you his opinion as an expert in the field of use of force and police training, including private security. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts he gave for his opinion and whether those facts are true. You should also think about the expert's qualifications and whether his opinion makes sense when you think about all the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. Matthew Clark is a missing witness whose appearance was the responsibility of the prosecution. You may infer that this witness's testimony would have been unfavorable to the prosecution's case. The witness, Charles Key, testified by video conferencing technology. You are to judge the witness's testimony by the same standards as any other witness, and you should give the witness's testimony the same consideration you would have given it had the witness testified in person. A person can use force in self-defense only where it is necessary to do so. If the defendant could have safely retreated but did not do so, you may consider that fact in deciding whether the defendant honestly and reasonably believed he needed to use force in self-defense. However, a person is never required to retreat under some circumstances. He does not need to retreat if he reasonably believes that an attacker is about to use deadly force or he is subjected to a sudden, fierce, and violent attack. Further, a person is not required to retreat if he or she has not or is not engaged in the commission of a crime at the time of the force is used, has a legal right to be where he or she is at that time, and has an honest and reasonable belief that the use of force is necessary to prevent the imminent unlawful use of force against himself or another person. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. The defendant claims that he acted in lawful self-defense in defense of others. A person has the right to use force to defend himself and other people under certain circumstances. If a person acts in lawful self-defense or defense of others, his actions are justified and he is not guilty of involuntary manslaughter. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense or the defense of others. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. First, when he acted, the defendant must have honestly and reasonably believed that he had to use force to protect himself or other people from the imminent unlawful use of force by another. Excuse me. If his belief was honest and reasonable, he could act at once to defend himself or other people, even if it turns out later that he was wrong about how much danger he or other people were in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect himself or the other people from danger. The defendant must have used the kind of force that was appropriate to the attack made in the circumstances as he saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting himself or other people. But you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself or other people only lasts as long as it seems necessary for the purpose of protection. And fourth, the person claiming self-defense must not have acted wrongfully and brought on the assault. Each defendant is charged with the crime of involuntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Mackenzie Cochran. That is, that Mackenzie Cochran died as a result of positional asphyxiation. Second, in doing the act that caused Mackenzie Cochran's death, the defendant acted in a grossly negligent manner. And third, that the defendant caused the death without lawful excuse or justification. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the death of Mackenzie Cochran was caused by the defendant, you must find beyond a reasonable doubt that the death was the natural or necessary result of the defendant's act. If the defendant unlawfully injured Mackenzie Cochran and started a series of events that naturally or necessarily resulted in Mackenzie Cochran's death, there is no defense that Mackenzie Cochran was already weak or ill and this contributed to his death. Gross negligence is an element of manslaughter. Ordinary negligence is an element of negligent homicide. Slight negligence is not a crime at all. Because of that, I need to tell you the differences between slight, ordinary, and gross negligence. Slight negligence means doing something that is not usually dangerous, something that only an extremely careful person would have thought could cause injury. In this case, if you find that the defendant is only slightly negligent, then you must find him not guilty. Ordinary negligence means not taking reasonable care under the circumstances as they were at the time. If someone does something that is usually dangerous, something that a sensible person would know could hurt someone, that is ordinary negligence. If the defendant did not do what a sensible person would have done under the circumstances, then that is ordinary negligence. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. The degree of negligence separates negligent homicide from manslaughter. For manslaughter, there must be gross negligence. For negligent homicide, there must be ordinary negligence. If the defendant was not negligent at all, or if he was only slightly negligent, then he is not guilty of either manslaughter or negligent homicide. The fact that an accident occurred or that someone was killed does not by itself mean that the defendant was negligent. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. If you find that Mackenzie Cochran was negligent, you may only consider that negligence in deciding whether the defendant's conduct was a substantial cause of the accident. And ladies and gentlemen, that concludes the reading of the instructions to you.
May we approach briefly?
Did I make a mistake somewhere? Sure.
And it wasn't your fault. It was our fault.
It's your fault. Okay, well, good. I'm so glad it was. All right, ladies and gentlemen, there's one more instruction that I have to add here, which I will do right now. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. I thought I read that.
You read that, but not the last two paragraphs.
Oh, I didn't read 8 and 9. Okay, I'm going to read the whole thing over. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. Have I corrected the error that I made the first time around?
Yes, Your Honor.
Yes, thank you. And ladies and gentlemen, as I told you earlier, at the beginning of this trial, we have chosen 14 of you. So at this time, my clerk is going to pull out by block from this box that contains your seat numbers, not your juror numbers, but where you're seated. And those two jurors will be excused from deliberating at this time. However, I do ask that the jurors that are going to be excused not discuss the cases with anyone until this sitting jury comes back with the verdict. The reason for that is, in case something happens to one of the sitting jurors before they reach a verdict, I would have to call in an alternate juror to begin deliberations again with the seated jury to reach a verdict. So it's important that whoever the two of you are that are going to be excused, not discuss the case with anyone. All right? Juror seat number 11 and juror in seat number 13. That would be you, sir, and that would be you.
Please rise for these jurors.
You don't have to. Somebody else does. Just give them a minute. I don't know if they have anything back in the jury room that they need to retrieve. And then I will release you to go to the jury room to begin your deliberations, ladies and gentlemen.
And then adjourn.
Yeah, as soon as they walk. Oh, yeah, she would have admitted.
All rise for the jury.
You may be seated.
Thank you.
Thank you.
Other than the,
I think A was something digital and B, C.
other than the objections that were argued on the record, is everybody satisfied with the instructions as they were given?
Yes.
Yes, Your Honor.
Thank you.
It was that video file that you did.
So that's on that question?
Yeah.
No, we just put together the exhibits.
Yeah, remember he gave it to me.
Yes, if you can gather the exhibits.
Yes, that's okay. Yeah, that's A and then.
I just
B
want
over.
to indicate that should the jurors want to see any of the actual videos, I'm going to bring them back in the courtroom because you only use part of the videos and some of them you muted, and so my clerks wouldn't know where to.
Well,
We could remove the other.
as it related to Exhibit 17, I wanted a point of clarification from the court. I actually prepared it in several different ways. When we discussed it for jury instructions, did you say that that would be no audio
Yes.
whatsoever?
Yes.
Then I have a copy with no audio on it.
Okay. But as I said, beginning and ending, I prefer that they just come out and view whatever they wanted to see, and you could just show what was shown during the trial.
Okay.
Okay?
Yes.
Just wanted to put that out there. All right. All right then. Thank you very much.
Yes.
And
All rise.
if you plan on leaving the area, please make sure my staff has your cell phone number so that if there's a question or if the jury comes back with the verdict, we know how to get a hold of you. All right? Thank you.
Your Honor, recalling People v. King, case number 2023-284855 FH. Calling People v. Marie, case number 2023-284856 FH. And calling People v. Cyberlin, case number 2023-284857 FH.
I have been informed by my staff that the jury has reached a verdict, so we're going to bring the jury.
All rise for the jury.
You may be seated. All right, ladies and gentlemen, I've been informed that you have reached a verdict in this matter. You are the foreperson? Yes. If you'll please stand. All right, as it relates to the defendant, John Seaborn, how do you find?
We, the jury, find the defendant, John Seaborn, not guilty.
As it relates to the defendant, Gavin King, how do you find?
We, the jury, find the defendant not guilty.
As it relates to the defendant, Aaron Marie, how do you find?
We, the jury, find the defendant not guilty.
All right, let's
Ladies and gentlemen, please grab your attention. Listen to the judge, folks.
thank you.
Please.
Would you all be seated, please?
Thank you.
Do you wish the jury poll?
No, Your Honor.
No.
Thank you. Ladies and gentlemen of the jury, I thank you for your service. If you'll return to the jury room, I'll be in briefly to speak with you. Thank you.
All rise to the jury.
All right, and thank you. At this time, the defendants are free to go.
Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town.
Justice is a process. Hello, Vinny, please do a show on the Franklin Tucker case. We need your help on this one. He's had his bond revoked and currently trying to disqualify the judge and the prosecutors. Yeah, we're going to do one. We're definitely doing one on the Franklin Tucker case. This is the one down in Key West. It was a trial on court TV. Hung jury first time around, represented himself. He did a nice job. I mean, he was very thorough. I think a real good lawyer could have won his case initially, because it was to me, there was some level of doubt that was very, very plausible to argue to the jury in that case. That was the Treehouse case down in Key West. But yes, we will be on that.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof.